Good morning, my dear students and friends. Welcome back in this course. I'm Professor Urus Ilyas, working in Department of Wildlife Sciences since more than a decade, and I'm teaching wildlife policies, mammalogy, population, and many courses. And all, of course, to undergraduate, we are teaching the environment study. We have recently developed a module on the environmental studies, and that was the third most registered module in AMU. So, in the continuation of my last lecture about the treaties or the convention, this is the third lecture I'll be delivering, that is the interpretation and reservation in treaties. What are the interpretation and what are the reservation in the treaties? So, we already know what are the treaties. Treaties are the agreement between more than between two or more than two countries. So, there are three types of treaties: bilateral, multilateral and regional treaties. So, we have already studied this, the nature of treaties, all these things. Now, we will be discussing about the interpretation and reservation in treaties. So, the treaty today represent the main regulate the international regulation because of the clarity and precision with which there are ascertained and agreements concluded between the subject of international law. Basically, treaties are the has to be governed or are to be with the international laws, because whatever treaty we sign, we have to implement that in our national law, and it is a global agreement. Treaty is a global agreement at the global level. So, interpreting treaties is a crucial aspect of understanding and implementing international agreements effectively. Without understanding, you cannot not implement the treaty effectively. So, it is important to understand and for the implementing international agreement effectively. So, interpretation is essential for ensuring that the goals and obligations are correctly understood and applied. Interpretation is the process of establishing the legal nature and the effect of the consensus to which the parties have reached. Whatever we have decided, whatever the members of the parties have decided, there should be one consensus. So the interpretation is the process of establishing the legal nature and the effect of the consensus to which the parties have been reached. So, reservation is a treaty or a declaration made by a state when it ratified to an international treaty, indicating that it does not agree to certain provision of the treaty or wishes to modify its application to itself. So, interpretation of treaties, the international treaty interpretation is very important, because we have to implement the treaty at the global level, at the national level and at the regional level. So, it is widely accepted that the treaty is nowadays the principal source of public international law. The best way to find and determine the international commitment that the state commit themselves as subject of international legal relation binding as a carrier of sovereignty. It was even believed that we live in the ages of the treaty. Everything is treaty. We have to agree upon something. So, we are living in the ages of the treaties. The international treaty is an important tool to influence international cooperation, a very efficient development and management method of international relations. The international treaty is the consistent manifestation of the will of two or more subjects of international law in order to produce legal effect of international law. So, this is the interpretation of the treaties. The Vienna Convention, the treaty of the treaty, the Vienna Convention of 1969, which codified the law of treaty. The international treaty is an international agreement concluded between states in written form and governed by the international law. Edwin Glaster noted that interpretation of a treaty to elucidate the meaning of its text, and they identifies three groups of issues that require the resolution in this regards. So, interpretation of the treaty, whatever we are agreeing upon, it is important to interpret that, to understand that, and for that Edwin Glad given three different resolution in this regard. The first is, what does it mean to interpret an international treaty? That is the object problem of interpreting treaties. Second, who has the authority to interpret the international treaty? From whom does it emanate a certain interpretation of a text? What authority, what legal effect does this interpretation have? That is the problem of interpretation way of treaty. And the third is the how to interpret the international treaty, that is consisting of international law, rules on treaty interpretation. So, form of international interpretation of treaties. The operation of interpreting international treaty may be achieved by the state parties of the treaty of international organization through specialized bodies and doctrinaries. So, we have to involve those who are actually involved in making the treaty. Practice and specialized literature have noted that according to the author of the interpretation can be authentic or inauthentic. The authentic interpretation can be collective or unilateral. Authentic, obviously, agreement can be collective or unilateral. This form of interpretation has a special feature in the law of treaties because on one hand, collective authentic interpretation is achieved by all parties of the treaty in the moment of adopting the text or letter, and on the other hand, when you are not agreeing upon. On the other hand, under the sovereign of each state party to a treaty can make their own interpretation and indicate the meaning that they attribute to the text of the treaty. So, internationally there are competencies to perform interpretation of the government authority bodies, usually foreign affairs minister of the state parties of the treaty. So, in every treaty there is foreign minister involved while making and interpreting. So, the interpretation made by the state party can also be achieved by amendments or by separate interpretation agreement. So, this is the form of interpretation of the treaties. The inauthentic interpretation is performed by body of an international organization. One was the authentic interpretation and there is the inauthentic interpretation. So, the inauthentic interpretation is performed by body of an international organization. The jurisdictional interpretation has also an inauthentic feature because it interprets the rule of law in its application. It does not create law and order, and the decision is only enforceable against the parties in litigation and only in the case of question. Doctrinal interpretation is achieved by specialists in scientific papers, and they do have legal obligatory forces. It is not authentic, but it can influence the creation and application process of international law norms. Depending on the result of the interpretation, it can take one of three forms: literature, extensive or restrictive interpretation. The ad libitum interpretation is that where the interpreter finds that there is no consistency between the legal text and the practical cases that can be included in the legal norm hypothesis. The other two forms of interpretation, there is no correlation between the legal text and the cases or practices. The utterance being limited or too broad in these condition, the interpretation must interpretation must. Now come to the rules and principle of the interpretation of the treaty. There are certain rules and the principle while you are interpreting the people. So there are the interpretation technique of the legal norms as regarded the treaty interpretation require four interpretation method. One is the grammatically interpretation, second is the systematic interpretation, Third is the historical and technological interpretation, and the fourth is the logical interpretation. So there are four different kind of interpretation. I'll be taking up one by one. Grammatical interpretation is requiring a legal standard international interpretation of the rules of grammar or syntax, morphology, vocabulary. Vocabulary changes a lot of, changes the meaning. It's all depend what all vocabulary is being used. So systematic interpretation is the which involves establishing the international legal standard meaning of a treaty by its relate to its whole text, to the legal institution or other provision of international law. And the third is the historical and technological teleological interpretation, which consists of clarifying the meaning of the term of treaty, taking into account the historical, social, political condition lead to the adoption of the documentation in question, and the purpose pursued by the state as parties to the treaty. In such cases, it should be considered the preparatory work for drafting the treaty text, the debate about the draft treaty within international confidence exchange and notes. And the legal interpretation, a method which leads to clarify the content of a treaty by use of reasoning and arguments of formal logic. In practice, states have established in the domain of conclusion and implementation of treaties, rules, methods, principle and procedure, used interpretation, which were codified by the 1969 Vienna Convention on the Law of Treaty. So this was about the rules and principle of the interpretation of the treaty. In the matter of treaty interpretation, good faith demand the compliance of the following requirement. If you are signing a treaty, compliance is very, very important for every party, for every state, for every nation, those who are signing. If the treaty is clear, the meaning should not change under the pretext of respecting the spirit. The used term in the treaty must be again assigned to their ordinary natural meaning, and they should be interpreted taking into account the object and purpose of the treaty. To a term, it will be assigned a special meaning if it is established that it was the intention of the parties. So, interpretation of treaty, there must be considered other fundamental principle of international law, such as the principle of sovereign equity of a state, the principle of peaceful settlement of dispute, the principle of inviolability of borders and territorial integrity, and the principle of representing human rights and fundamental freedom, etc. So, the interpretation process required compliance with rules of interpretation that the state have codified by 1969 Vienna Convention on the Law of Treaties, which establish parameters where the text of various treaties must be understood. The interpretation of a treaty should lead to clarification of ambiguous term and to determine the real intention of the parties concerning the right obligation establishment by the text. Reservation of the treaty. Reservation to treaty is one of the complex and difficult issue in the law of treaty and in the state practice which respect to treaties. The essence of a reservation is to attach certain condition to the consent expressed by a state to be bound by a treaty. There are two aspects that need clarification. One is that a reservation is, in order to be admissible and effective vis-a-vis other parties to treaty, has to be accepted by them. If any country is asking for the reservation, that should be acceptable to other parties also. So, reservation is a process, is a is reservation is also one of the process under any treaty. If I am signing any treaty and I have some reservation, for example, I can give an example. When the CITES was formed, Convention on International Trade, when the CITES convention took place, UAE signed the treaty, but they have reservation because they had a national game in which they were using the aquila species, the eagles they were using, and under the CITES all the wildlife products are prohibited. You cannot use. It was to control the trade, and the aquila species was involved with the international uh, involved for their national game. So they filed for the reservation that they should be exempted from this species, they should be allowed to use this species, and for the rest of the species they are signing the CITES, they are signing the treaties. So this is the reservation, and that should be acceptable to all the countries, then only the reservation is approved. So once the reservation, in order to be admissible and effective vis-a-vis other parties to the treaty, has to be accepted by them. The other is that no international obligation can be imposed upon a state without its acceptance, either explicitly or implicitly. It follows that a state can withhold the application of certain provision in a treaty by way of reservation, like the persistence objection state in the formation of customary rules of international law. If you have customary rules, you can always ask for the exemptions, reservations, and reservation can be granted provided the other parties of the state are agreeing upon. So this is the reservation, and a reservation is defined as unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereas it purports to exclude or to modify the legal effect of certain provision of the treaty in the application to the state. I have already given the example of the aquila species in UAE. They have filed for the reservation and reservation was granted. They are exempted from using the species. Theoretically, reservation may be made to any treaty, bilateral and multilateral. Reservation, you can file the reservation under any kind of treaty, whether it's a regional, lateral, bilateral or multilateral. Reservation is reservation, any countries, and this is the nation can take independent decision. As the International Law Commission state, reservation to a bilateral treaty present no problem because it amount to a new proposal reopening the negotiation between the two states concerning the term of the treaty. If they arrive at an agreement either adopting or rejecting the reservation, the treaty will be concluded. If not, it will fall in the ground. The traditional rule on reservation to multilateral treaty were developed upon the perception that a treaty resembles a contract in the municipal legal order, where once the term have been agreed upon, the contract can be modified with the consent of the parties. A representation made by a state can be assimilated to an offer which must be accepted by all the contracting parties to the treaty in order for it to produce legal effect. Whatever reservation, even if the India is filing for the reservation, that should be acceptable to all the parties of the treaties. Any objection to a reservation would have as its consequences that either the reserving state withdraw its reservation. If the other country is not agreeing upon, I can withdraw my reservation and become a party without the reservation, or insist on its position and does not become a party. If I file for a reservation, every nation has to be agreed upon, then only I can sign the treaty. If they are not, so it's up to me whether I want to be the party of the treaty or not. So, it is position and does not become a party. Formulation of reservation admissibility. Article 19 of convention follows a permission approaches to the right to formulation reservation. It provides the state may, when signing, ratifying, accepting, approving or acceding to a treaty, formulate a reservation. The first half of an article sets out in clear terms the right to formulate a reservation as a matter of general principle. But as indicated in another part of the article, the right circumscribed by 3 exemptions. The reservation is prohibited by the treaty, that is the first. The treaty provides that only specified reservation which do not include the reservation in the question may be made, or in case not falling under subparagraph A and B, the reservation is incompatible with the object and purpose of the treaty. So, this is the formulation of reservation admissibility. The formulation of reservation is a unilateral act. It's all, if I am asking for the reservation, I am filing for the reservation, this is unilateral. If the countries, the other parties signing the treaty are agreed upon, then only I will get the exemption. Otherwise, this is the unilateral act. This is not the other party. This is my act, whether I want to join the treaty, sign the treaty without reservation or not. If it denies, the other parties denies. There is presumption that a state exercises its right to formulate reservation in good faith, and that it does not make any reservation that will supposed to be contrary to the limitation of Article 19. Under some regional human rights conservation, the parties have indeed vested monitoring bodies with the power to rule on issues relating to the interpretation and implementation of the convention, including the validity of the reservation made thereto. Different perception of the limitation to the right to formulate reservation have led to the development of 2 different doctrinal view of the nature and function of these limitation, resulting in quite different modes of application of the rules. Acceptance and any object. The principle underlying the whole system is that no obligation can be binding upon a state without its consent. Nothing is binding on us or any state. In order to a possible, a reservation has to be accepted by the other parties to the treaties. If there are more than 3 countries signing the convention, signing the treaties, so it's up to them whether they are accepting or not. Acceptance can be explicit or implicit. Article 20 encompasses 3 acceptance rules: unanimity, collective decision and individual response. Either there should be unanimity, there should be collective decision or individual response. So, Article 20 encompasses 3 acceptance rules. It is generally recognized that the individual response in the basic rule, while the other 2 are to be seen as less specialist. In temporal term, there are 2 ways emphasized in Article 20. A reservation can be accepted either in advance, as in the case of reservation expressly authorized by the treaty, or subsequently. Objection to a reservation. What could be the objection? I am not ready to follow your what you are saying, I am not agreeing upon. So, that is the objection. If there are more than 3 countries signing a treaty and 1 country filed the reservation and I do not follow that reservation, I have objection. So, we will be discussing that objection to a reservation. The objection to a reservation is the design to counterbalance the right to formulate a reservation, with which it shares the legal presumption that a state cannot be subjected to any obligation without its consent. So, if you are objecting, you have to give the proper justification. Both are based on consensual conception of international law. Under the traditional reservation system, object would have an absolute effect treatment to a viral veto of a single state to keep out another state, despite the fact that the latter's participation could be valuable even on the reduced basis. Even a writer who was very critical of the flexibility approach adopted by the ICG pointed out the need to mitigate the unanimous consent rules somewhere, so as to permit the state to participate with reservation, provided this reservation is accepted or not objected to by the great majority of the other state parties. Thank you. This is all about the treaties, the interpretation of the treaties, and see you in my next lecture. About the next lecture is again about the treaties and all. Thank you very much.